specifics and illustrations of the strong protective role played by federal habeas. We think that the petitioner can't, on the one hand, laud our strong, robust judicial system with which we agree, and then say it's a fig leaf and is hollow and cannot give relief. In fact, in earlier cases before this commission, in the juvenile justice case of life imprisonment without parole, there's also some concern that the likelihood of relief within our domestic judicial system was very improbable. And of course, as you may know, on Monday, our Supreme Court is entertaining oral argument on the constitutionality under the Eighth Amendment of imprisonment without parole for crime committed by a juvenile. So we reject that the remedies are hollow and empty. The remedies were just initiated last week. There's a full hearing or a full proceeding before the Federal District Court. Then there are limited rights of appeal, both to the Court of Appeals of the Fifth Circuit and the Supreme Court. And we believe that it's a principle, as outlined in our brief of international review and adjudication, that the domestic courts, independent and robust, should be afforded the first opportunity to recognize a violation and grant relief. The 2004 hearing, which is the heart of the petitioner's claim, has not yet been reviewed by a federal court. There is an opportunity, if wrongs have been committed, to right them. And so we would like to underscore the importance of this habeas relief for the proceedings to be allowed to go forward under our federal system, particularly with all the constitutional protections that are afforded. Many are outlined in our submission, particularly in regard to the mental disabilities claimed by the petitioner. But I now turn to my colleague from the Justice Department to express in particular and to answer any questions about the federal habeas protections applied to petitioner. Thank you.
Good afternoon, Commissioners, Counsel for Petitioner. Oh, I'm sorry. and others present. I have very little to add to what Ms. Brancato has stated, other than to emphasize the following, and that is that no federal court, the petitioner is challenging his death sentence that was imposed in 2004, and no federal court has had an opportunity to review the claims that are raised with regard to that sentence. The defendant in the petition, the habeas petition that he filed in federal court last week, has raised all of the claims that are raised before the commission here today. He's raised his incompetence. He's asserted his incompetence at the time of his 2004 sentencing. He's challenged the evidentiary rulings that were made at that hearing in terms of admitting evidence that was offered by the government and excluding evidence that was offered by the defense. The defendant has also raised and argued his the violation that he alleges resulted from his detention in solitude in the current restrictions that he's under and his accompanying loss of mental health. And that's in Claim 9 of his petition. So all of these claims that are being raised before the commission here today are raised in the federal court for the first time. Counsel for petitioner does not argue that the federal courts have been ineffective in what they've in their prior rulings in this case. In fact, it wasn't just the Supreme Court, but it was also the Federal District Court in Texas that granted him relief. It was, in fact, it was the federal court where he's filed his petition now that actually set aside his death sentence, his prior death sentence. So that's not an ineffective venue for him. Federal habeas corpus, and this is an initial federal habeas corpus, and I think that's a very important point. Second habeas petitions of challenging a sentence or conviction are treated in a totally different way. But this, for purposes of Mr. Saldaño's death sentence, 2004 death sentence, this is an initial federal habeas, and the Supreme Court has stated that. The United States Supreme Court has stated that although state court rulings in state capital cases or non-capital cases are considered carefully, they're not rubber stamped by any means. They are given, a federal court has a firm duty to exercise its independent review and judgment on federal constitutional claims. And in that respect, it's been stated already, we have a dual system for reviewing convictions and sentences in in the United States, and one is you have your normal appeals, which go through the way an appeal typically would, what we call direct appeals. You have a trial, and then you can appeal to an appellate court and then to another court. But we have a backstop system, which consists of a separate federal judiciary, totally independent of the state where the sentence and conviction was imposed, and those are life tenured judges who have no prior contact with the case, or no prior dealings in the trial or in the prior appeals in the state system, and those judges jealously guard their ability to review and their independent jurisdiction over these cases, and those obligations are discharged very diligently and with great integrity. So we request, in the past, this commission has had this proceeding pending before it for a number of years. We have allowed the federal system to the appeals of the initial conviction and death sentence to become exhausted. The federal courts granted relief in this case. He's now been sentenced to death again, and for the first time, the petitioner has raised a petition challenging his death sentence imposed in 2004, and we respectfully request that the commission allow that process to carry itself out as it did with regard to the prior conviction and sentence. Unless the commission has any further questions, we'll submit with that.
Muchas gracias. Vamos a hacer entonces una ronda de preguntas para que respondan primero los peticionarios. Vamos a hacer una ronda de preguntas para que respondan primero los peticionarios y luego los representantes del Estado. Comisionado Piñeiro, que es el relator de la Comisión para Estados Unidos, primeramente.
Muchas gracias, señor presidente. Quería, en primer lugar, saludar los esfuerzos del Estado argentino, los representantes de Argentina en seguir ese caso. Creo que es un comportamiento que merece saludos en términos de la lucha contra la discriminación. Quería también agradecer todas las informaciones que el distinguido representante de Estados Unidos trajeron para esa conversación, para esa reunión. Desde el día que leí ese caso, estaba me preguntando qué termo diplomático iba a utilizar para me referir a ello. Eu creio que es un caso emblemático, es un caso iconic, en inglés eso es muy bueno, y icónico, porque en los últimos 6 años que estoy aquí tengo acompañado varios casos de pena de muerte, pero no me recuerdo un caso de que en concentrado estén tan presentes, y no voy a repetir toda la argumentación porque debemos pensar en el futuro, no solamente en calificar el caso, pero que están presentes la discriminación, el diálogo del fiscal con el experto es una cosa extraordinaria. Estaba preguntando si en la categorización de razas, ¿dónde se sitúan los argentinos? Estaba me preguntando, ¿dónde se sitúan los brasileños? Nosotros nunca fuimos hispánicos, hay un problema. Dices, no, los argentinos deben ser considerados hispánicos. Y eso como garantía de periculosidad futura. Pero eso fue superado por las grandes garantías del sistema jurídico americano. Pero el segundo es la discriminación de alguien con severa situación psiquiátrica. Creo que eso fue ciertamente, como los peticionarios presentaron, fue agravado por todos esos años mantenido en ese cubículo. Lo que quería preguntar a los peticionarios en esa visión constructiva, después de toda esa longa acción en el sistema jurídico americano, primero la proposición que ustedes mencionaron de la posibilidad del Estado federal se asociar a apoyar el pedido de habeas corpus. Si usted podría elaborar un poquito más eso, le agradecería. Y para el distinguido representante de Estados Unidos, hubo una proposición de una